SJC-11901, Cami Verdrager v. Mintz, Levin, Cohn, Ferris, Glovsky, and Popeo, PC, and another.
Good morning.
Good morning.
It's our one and only time doing this, so I hope everybody is celebrating the moment of it.
Good morning. May it please the court. My name is Cami Verdrager. I'm the plaintiff appellant in this matter, and I'm here today because I believe I'm entitled to a jury trial. The trial court failed to follow the precedent of both this court and the United States Supreme Court in applying the summary judgment standard. At every opportunity, it ruled at weighed evidence, found facts, failed to consider the evidence in the light most favorable to me, and assessed the credibility of witnesses, all of which are established as improper on summary judgment. One of what I feel is the most egregious examples is the trial court found that in terminating my employment, the defendants could not be held liable because Mr. Popeo genuinely believed, that's a quote, that I had violated the ethical rules and the policies of the firm. Genuinely believed is, of course, a witness credibility.
Let me just ask you about that, though. Take out the word genuinely. Do you disagree, or is your position that the reason for Mr. Popeo's action at that particular point in time was something other than his perception of the related to the looking at what was on the death serve, if I've got the name of the program right?
Yes, I do believe that, and I think there's ample evidence in the record of that. First of all, they were trying to fire me anyway. They had offered me a settlement and were trying to get me to leave.
This is the 2008...
termination.
Well, that was the 2008 general sort of crash of the marketplace when lots of layoffs were going on, right? And you were to be among one of them. You were scheduled to be one
It was
of them.
before the two. It was at the beginning of that. Sorry, yes. But I was the only ELB attorney selected, if that's what you're referring to, and I was supposedly selected based on having low billable hours, but I did not have the lowest
And
billable
when did you
hours
come
in the
back
section.
from maternity leave?
I had 2 maternity leaves while I was at Mintz Levin. I had returned from maternity leave after my second child in September of 08, I believe.
So this...
No, yes, February, yeah, September of 08.
So this event was in November?
This was in November of 08, yes.
Okay.
And are you saying that Mr. Popeo was involved in that decision to lay you off, or...
He was, Your Honor, and that was one of my next points. The decision to lay me off was not made by the ELB section, which of course would be the standard practice in a firm. It was made by the litigation defense team. They do not dispute this, and by litigation defense team, I mean the team assigned
Can you
to
just slow down a little
Sorry.
bit?
It's a team assigned to defend against my litigation.
And that was who?
That was Mr. Popeo, Kim Marcan, Michael Gardner, general counsel for the firm, and Pat Sharkey.
So the decision to have you be among those laid off in 2008 was made by the litigation defense team?
Yes, Your Honor.
But that didn't happen.
That did not happen.
And you were offered a settlement?
I was.
And that discussion was going on when?
At the same time, as soon as I learned of the layoff, I went to speak to Mr. Popeo about the voicemail transcript.
You went to Popeo to talk to him?
I did, yes.
I thought you spoke to somebody else first.
He wasn't available. He was in London on business, and I then went and spoke to Kim Marcan, who I knew.
And then she told, or he told, Mr. Popeo?
She's testified that she did, yes.
Okay. And then, so within what time frame was this? When did Mr. Popeo make the decision to terminate you? When did you receive the decision that you were terminated?
I don't remember the exact
Well, just
date.
roughly. We're talking weeks, months?
Oh, no. This was within a week and a half, probably, of learning. Not even. I'm sure it was less than that. I'm sure it was a few days.
And had you turned down the settlement offer before that?
I had turned down a few, yes.
In that period of time?
In the time period from when I think the first offer was made in the summer of 2006, so from the time period of 2006 to 2008.
But I think Justice Lank is talking about a settlement offer relating to the layoffs.
Yes.
Oh, no, I'm sorry. No.
Not the runway piece.
No, sorry, no, I had not. Only one settlement offer from the layoffs.
I'm sorry, could you explain that? You said that you had a settlement offer in connection with the layoff,
Correct.
and that was in that same period of time, in 2008,
Yes.
and before Mr. Popeo terminated you.
Yes.
So prior to the time the conversation with Kim Marchand was the name?
Marcan. Yes.
Marchand happened, you'd already turned down the settlement offer.
Actually, I turned it down in my conversation with Kim Marcan.
Oh, okay. So they were contemporaneous.
Yeah, we agreed that we would consider it a settlement discussion so that we could speak freely because I was not with my attorney at that time. And I let her know that I would not be accepting the offer and that.
So your position with, again, putting retaliation aside, your position with respect to Mr. Popeo's decision in November of '08 to terminate you was that the reason given relating to the what was on the internet was that is itself the pretextual reason?
Yes, Your Honor, and if I may, the most compelling reason, or the most compelling evidence for that is that Mr. Popeo himself testified at the BBO, and I'm quoting here, that he said the policies, quote, play no important role in terms of my decision to terminate. So this idea that they fired me for violating the policies, that's actually a new idea. He also testified at the BBO in the case of Cami Verdrager, she was an adverse party, and he went on to say she penetrated the attorney-client privilege as an adverse party for her personal use. So this, and then finally, the case actually came to Justice
That seems
Spina.
inconsistent with the first thing that you read. I mean,
Well, I think there are two thoughts there. He considered me an adverse party because I had filed the discrimination claim, which that's what retaliation is supposed to protect.
I know,
in my
I'm not
view.
talking about retaliation right now. I'm still trying to just figure out what you say was the pretextual reason for the termination, because that's one of your claims.
The reason that they are advancing today is that they fired me because I violated my ethical, my duty of loyalty, and I violated
You
the
say that's pretextual.
policies of the firm. That is pretextual. Mr. Popeo also sent out an email after I was terminated where he talked about my conduct and it being a violation of privacy rights and duty of loyalty, and did not mention the policies of the firm. That actually is not in the record, but it is below at the lower court, and the sanctions decision cites to it. I can tell you how to find it. It is part of the trial court record.
So basically that Popeo, what I'll call the Popeo termination, was, it's actually both things. It is retaliation and?
I believe it is, Your Honor, yes.
And those are two separate claims that you have.
Yes.
But that's only as to that, as to the extended track.
Yeah, I think that that's a decision for the jury. I mean, that's why we have the jury process and fact finders. I can believe what I believe, they believe what they believe, and you believe what you believe, but really that's ultimately a jury question. What was the real reason for the termination?
But,
Well, it's a jury question only if you do what you have to do to get to the jury. You don't automatically get a right to get to a jury. You have to establish in some way that Mr. Popeo's reason for the termination is pretext, or it's not the real reason.
you have to put forward some admissible evidence that a jury could find that to be the case.
Correct, and I believe that I have. I think that the shifting reasons, as we know, is for an explanation for a termination is admissible as evidence of pretext. His shifting reasons, again, the policies were never a factor until much later.
I wasn't actually asking about the policies per se, but what you did with respect to, is it desk serve? Do I have the name right?
It's desk site, Your Honor,
Desk
yes.
site, sorry.
That's okay.
What you did with respect to desk site, the actions that you took, whether right or wrong, that was the reason that he gave and asserted for your termination.
The other reasons, in addition to the shifting reasons, in addition to the fact that the litigation defense team selected me, and one of the other more compelling reasons is that the desk site system and the policies of Mintz Levin, the documents I looked at were in a section called public. They were open to every single person.
I know that. I guess I'm getting to the point of that sort of goes to retaliation or protected activity. But I guess all I'm saying is, I'm trying to look at the termination decision as discriminatory and pretextual, and it seems to me even if even if Mr. Popeo's reason, if it related to that, even if it was wrong, it didn't have a basis, but if it wasn't because of your gender, then on that claim, I'm having trouble seeing how you could go forward.
Okay. I believe that the best evidence of that is the fact that, again, it was supposedly based on hours, and I was not the lowest hours in the section. I was also the only ELB attorney selected. And then if we dig into the hours question, there's the problem of the fact that I had higher than average ELB attorney hours before I gave birth to a child. It was only after I returned from maternity leave that my hours dipped below the average ELB associate, and ultimately, as things continue to progress in a negative direction, really dip below what average ELB associates were. So that's the gender piece in respect to how I was being selected.
Could I shift your attention to the particular documents that you retrieved from the desk serve? I looked through the record trying to find exactly what it is that you got, and I didn't have much success in figuring that out. Well, would any of the documents that you retrieved have been available to you under Rule 26 discovery? Was there anything that you got that you couldn't have gotten through ordinary discovery?
There isn't, but they haven't produced those things. I mean, they have continued to not produce things throughout. So
well, that's kind of beside the point. I'm trying to figure out here if there is a good policy reason to allow an employee to access internal documents, and one would be if there's something important that you fear that the employer is going to destroy, or if it's not ordinarily discoverable. Why should you be allowed to access the records for documents that you're entitled to get under discovery?
I think there's two different answers. The first answer is I did have a reason. I had spoken to Dawn Galena, and she had told me about her battle. She was the prior litigation against the firm and how they had stonewalled her in discovery. And I had every reason to believe that I wasn't going to be able to get even basic things like my own emails, which I have not gotten in some cases. The second reason is I think there's a policy reason that should allow employees to have this informal discovery and have access. Why shouldn't an employee be allowed to retain documents that they're entitled to have access to as long as they don't misuse those documents? And as long as they're in a public place. I think the distinction here on...
Let's talk about the public place, because I'm not sure public means that people outside of Mintz Levin have a right to access. I mean, I couldn't go in there with a password and get access to the documents. I think public means that it's available to people who work there. It doesn't mean that it's available to your lawyer.
That's correct. It's public within the firm. However, within the firm means every single lawyer and administrative employee within the firm. It also is, that designation is accompanied by firm policies and firm training, where you're told repeatedly that there's no expectation of privacy for anything you put on the system.
As far as people who work at Mintz Levin, not outside the firm. That's not what it means, is it?
No, but I was someone that worked at Mintz Levin, so to prevent me, I was entitled. They had no expectation of privacy as to me,
right.
And those documents.
But
they did have a right to expect that those documents, whatever is on that system, is not going outside the firm. Isn't that right?
I believe that they had a right to expect that the documents wouldn't be misused. I don't believe.
No. My question is outside the firm.
I don't believe that that's true when it comes to sharing documents with an attorney. I researched what Massachusetts law was at the time, and I think Massachusetts law is clear that you have to be allowed to share documents with your attorney. I also only shared 2 documents with my attorney. Most of the documents I was retaining and preserving for evidentiary purposes.
So could you turn to the retaliation claim?
Yes.
Is it your, which relates to the question that Justice Hines just asked you, but is it your position that basically that because of what you were, where you were and the claims that you were alleging, that your search through the desk site, is that?
Yes.
Okay. Your search through the desk site was protected activity that can't, all of it. Is that right?
That
I mean,
is
are there
correct.
any limitations on what would fall within the realm of protected activity?
I
in
think
your
there
view?
are limitations, and I think most of those limitations come into, would come into the access and the reasonable use. But I have to say, ultimately, these are all jury questions, I believe. The jury has to decide, did Mr. Popeo fire me because he really genuinely believed I did something wrong, or because I did do something wrong? Even if you think I did something wrong, it's still a jury question that after the jury
But
weighs
you're
the
asking us to
evidence.
say that that was protected activity.
Yes, and I do believe it was protected
That's something
activity.
that's not a jury question. That is a
I-
legal question.
That is a legal question. I think it's an important legal question. I'm delighted that I'm here today talking about it. I think that there has to be a baseline of conduct that employees are protected, and that has to include keeping documents that they have access to legitimately through their employment and sharing those documents with their attorney. I do not believe that I would be protected if I went into private offices or private filing cabinets. I was in a public place where I knew no one had an expectation of privacy.
Let me ask you a question. Do you agree with the amicus position on the New Jersey case, coupled with the twist given the doctrine by Justice Spina? Or do you take a different position on that?
I take a different position, Your Honor. I'm a lawyer, and I looked at the law. I think that when you look at the Quinlan case and all of the factors, I think that's too much for any employee to be expected to navigate. That's why I suggest that the court should have a baseline of conduct, which is documents you're entitled, you have access legitimately through your employer, and that you don't misuse any disclosures limited only to your counsel. That's actually consistent with the position enunciated. It's a case cited in the amicus, State v. I can't pronounce it, Verdrager, which was a case following Quinlan. The dissent talks about that the Quinlan factors, they might make sense if we're not sure about what was done with the documents, if we're not sure that it was reasonable, because reasonable is a fair question in this context. But a baseline of reasonable should be the employee legitimately had access to them during their employment, and they did not disclose or misuse disclose anyone other than an attorney.
Your time is up, but I have another question. Is it your position that you are entitled to look at the firm's draft position statement in response to your MCAD complaint? I mean, that's something you would never be entitled to, but you access that.
I'm glad you raised that, Your Honor. I didn't look at that. Part of the problem.
Did not?
I did not. Defendants have created a lot of misinformation, and this is what's really informative to the court here, I think, is the BBO decision, the hearing committee report, and ultimately the board's decision and Justice Spina's decision. I was able to establish before the BBO that I did not look at that, because what they did was they produced this confusing spreadsheet, but I was able to show how when they testify that when you click through documents, it creates a view, even if you don't open the document. So if you pull up a search of documents and you click through a list, it registers as view. I was able to show through their spreadsheet, which was limited. They never gave me a full chronology of my activity on the system. It was their tailored,
Okay, you were able to
view.
show.
I was able to show that there was 3 other documents, I believe, I looked at in the same minute. I obviously did not open and review the very lengthy MCAD position statement. I've never opened, I didn't care.
Well, the system says you had a view.
No, the system registers a view, and their IT witness testified that the system will register a view whether you actually open it or not. If you scroll down the list of documents, it comes as a view. The way the system works is it has like a preview pane. If you actually open it, it will register as a checkout. And they have an exhibit there's an exhibit in the appendix where you can see the difference. The ones that I checked out are the ones that I actually opened.
Okay.
So could we, excuse me, I didn't really understand what the answer to the question was that I think Justice Hines asked before about where do we look if we want to see what documents you looked at? Where in the
Actually
record?
accessed.
Yeah, where do we look to see that? Is that in the record anywhere?
It is, but it isn't. It's in some of the BBO records. Some of the BBO materials are there. My testimony is there.
So if we went to the BBO materials, we'd be able to find that.
Yes, but you don't have before the court, because defendants have never submitted, Justice Cosgrove talked about that in his decision, you don't have the actual documents because they were never...
Did you submit an affidavit, not in connection with the BBO, but in connection with this case before Judge Laureate, explaining what you did and did not actually access?
I don't believe I submitted an affidavit, but I did talk about it in my argument and in my papers, and I've never disputed what I did take. I mean, certainly the voicemail transcript, I've never disputed it. I think that's an important, relevant document.
Okay.
Thank you.
Ms. Lukey?
Thank you. May it please the court, Joan Lukey, and with me Justin Wallace on behalf of all of the defendant appellees, Mintz, Levin, and the 5 individual named members. Let me just quickly say that there were several statements made by Ms. Verdrager that do not have record support anywhere, including that the layoff decision, apart from the fact it's irrelevant because it didn't happen, she purported to say was made by the defense team. You will not find that in the record. It is not accurate. Mr. Popeo's testimony before the BBO, as to which you do have excerpts, although we believe those proceedings are not relevant since Mintz was not a party to them and they were decided under other rules. That is in what she included in the record appendix. He did not state that the policies were of no import. And with regard to her statement that the settlement was to end or to settle the layoff decision, that is also not supported in the record. You will see the timing is she had filed her complaint of discrimination in December of 2007. Mediation had gone forward. The settlement was an effort to resolve the litigation, and it would have required a full release. So in that sense, all issues would have been gone.
Can I ask you, is there any evidence of record as to who was part of that litigation team, and was Mr. Popeo part of that litigation team?
Yes, there is evidence in the record at various points in excerpts from testimony that were appended to the summary judgment materials before Judge Laureate.
So it's really undisputed that he was part of the litigation team?
He was certainly part of the team that was overseeing internally the litigation, but the chronology
And
presented...
so he was aware, there's no question that he was aware of all of the factors relating to the decisions with respect to Ms. Verdrager?
Yeah, he did not know Ms. Verdrager, but certainly as the chairman of the firm, Your Honor, he was aware
Not
of
just
that.
as the chairman of the firm, but as part of the litigation team.
Well, he was on the litigation team because he was the chairman of the firm, but yes, Your Honor, he had awareness. But if I may, I'd like to turn to Justice Hines' question about where we can find a record of what was removed, and then I would like to tell you...
Well, when you say removed, what you mean is copied, don't you? I mean, it wasn't actually...
Well, it was sent out to her private email account, and then from there to her attorney.
Right,
and
but it's
There's no
not
evidence that it was ever to anyone other than her attorney?
It was never, to our knowledge, sent to anyone but...
There's no evidence as to that?
There is no evidence it went anywhere but her home AOL account. From there, we don't know where it went, except she acknowledges sending 2 documents to her attorney. And there are several cases that say that that doesn't excuse this.
Yes, but Quinlan seemed to, I think it's Quinlan.
Quinlan, in fact, the New Jersey case says it is not protected activity to find materials, even when they're available to you as part of your job, and send them to yourself and your attorney. That is not protected. If the attorney uses them in the process of the litigation, it then moves from the opposition clause of Title VII in that instance into the participation clause. If you are using documents in the actual act of testifying or doing discovery or filing a complaint, that is participation clause, and that will be protected in almost all instances. The first clause in Title VII, 2000E3, and in this instance, the analog statute 151B4, Section 4.
So can I just get that straight? You're saying that if her attorney, instead of Ms. Verdrager, had come in to see Marchand?
Marquand.
Marquand, I don't know why I'm sorry about that. Marquand, and said exactly the same things, including, look at this voicemail transcript that we have from Mr. Popeo, that would have been protected activity?
Not at all, Your Honor. That the activity in which she was engaged was not part of formal discovery. Discovery had not begun in the MCAD, and it was not part of testifying. The cases I can give you, you of course note from your own solicitation for amicus briefs that there has been no case on point in Massachusetts, but the cases around the country, and they are quite uniform on this issue and not dealt with at all in Ms. Verdrager's brief, but dealt with extensively in the appellee's brief, as to which documents were removed because the person had legal access to them. They could get them if they wanted them, and sent to the attorneys are Niswander v. Cincinnati Insurance, a Sixth Circuit case.
We do talk about that one a lot.
Yes. Well, it's very, very similar in facts, except that I'd like to come to the fact that what she took was a 106-page transcription of privileged client voicemails. That's what I want to get to with you in just a moment, if I may, because no case anywhere has ever said that it's okay for an employee to take attorney-client privileged documents and send them to anyone, to use them for any purpose. That is a first, and that is the issue that is most troubling here. It is the reason that Mr. Popeo testified he terminated her immediately upon learning of it.
Testified where to that?
He testified both in his deposition and, well, in this instance, it would be in the Board of Bar Overseas Proceedings.
So that is relevant in that regard.
Judge Laureat looked at that, and he looked also at the deposition testimony. So he looked at whatever was submitted.
Because I haven't looked at the record, the summary judgment record, but was part of it the proceedings in the BBO, at least the testimony that Mr. Popeo gave and anything else that was in the BBO?
Mr. Popeo and Mintz Levin were the complaining witness to the BBO. He testified that he felt obligated to report her because she had removed
Right, I'm just wondering,
client
because there was
materials.
obviously a transcript of a hearing there. And
That all that you have, well, it may be that in the single justice
Right,
proceedings
but
you
I'm not
have other
talking about that. I'm
materials.
just talking about the summary judgment record.
You have bits and pieces of it, Your Honor, including pieces of Mr. Popeo's testimony. Judge Laureat deals with it in his lengthy opinion, in which he points out that even in the course of that proceeding, as well as in the course of all the depositions in this case, at no time does Ms. Verdrager ever come up with any evidence. His phrase is literally, there is no evidence of either discriminatory or retaliatory motive in any adverse employment decision. I know that you will review his decision with care. It's lengthy.
Well, there are two of them.
Judge Cosgrove is the other one. He did a lengthy sanctions decision in which he made the actual finding that, and he is the one judge, the only person who had the full 106-page voicemail transcript. It is filed impounded. We asked him to take it and impound it. He reviewed it. It is in the Suffolk Superior Court. Under Rule 16M, we are told to reference you to impounded materials, but not include them in the appendix before this court. That is what we do. It's in one of our footnotes. Should you wish to review it, as opposed to seeing Judge Cosgrove's detailed recitation of what's in that 106-page transcription, it is available to you under seal right next door.
Do you take the position, let me ask it this way. In the case of Ms. Verdrager or anybody, given the policies with respect to employee access to the public part of the desk site, is there any piece of that that would be, in your view, non-violative? I understand the emails are sort of at one end. I'm just wondering, is this a continuum or is it anything?
According to the policy, the confidentiality policy, which is before you in the record at pages 1497 and following, any document, this was not the emails, by the way, that she accessed. She has no access to those. This is the draft document site where work is being done on actual documents.
But
Any document produced.
Weren't they copied, the emails copied and put on there?
Oh, what was copied was voicemail
Sorry,
transcriptions.
voicemails. I misspoke. I meant that. Yes.
Mr. Popeo's assistant created a Word document that she kept open and on a running basis transcribed his voicemails.
That's what I meant, sorry.
That was in there, and that is the focus of the defendant's concern, and it is what Mr. Popeo said was the reason that he terminated her. And what Judge Laureat said is, I have looked at this, and she has come in with no evidence that that is not the truth. The reference to shifting reasons quite took me by surprise. From the moment that Mr. Popeo learned that she had accessed the desk site, he did what the law actually requires him to do without even realizing what the case law says, because there are half dozen cases around the country on this same point coming out the same way. That is, instead of reacting angrily and instantly, he had the IT team review what she had reviewed and then what she had taken. You can tell when something is sent out. In the record appendix, there is the spreadsheet showing everything, but the focus that the defendants have in this matter is that running transcription.
And you say that's attorney-client privileged?
Your Honor, there are so many attorney-client
Oh,
privileges, yes.
Is that one attorney-client? Why is that attorney-client privileged?
Because it's clients leaving messages for Mr. Popeo, and I will say to you what I said to Judge Cosgrove at that hearing. If you read it, and we strongly encourage you to get it, even though we're not supposed to submit it, to have it pulled from the impoundment section next door. If you read it, it would even curl my hair, was literally the phrase I used. These messages, in some instances, are so distraught that it is, you feel voyeuristic to be reading them. And you can tell who the messages are from because they identify themselves.
The
Hi,
clients,
Bob, this is...
This is the clients do.
Yes,
So this
Your
is
Honor.
not just a voicemail having to do with the conversation regarding gold.
Not at all. That's one voicemail in the middle of a 106-page document.
How much of it has to do with gold? That conversation?
There's a paragraph.
Well, isn't there that conversation that somebody in the
Washington?
in the other office is basically saying, you know, this guy's a big problem, and he really shouldn't be involved in...
There's one paragraph relating to the litigation earlier that was referenced, not this litigation, but Ms. Galena. It was a paragraph in which a partner in the DC office who was on the policy committee said to Bob, as chairman of the firm, you know, Bob Galt is just too, and Mr. Galt's here, so this is awkward, but Bob Galt's just too defensive. He refuses to accept that anybody here could actually have done anything wrong. We need somebody who's more open-minded. That's what it says. And frankly, we don't care that she has that email, and had she followed, or that transcription of voicemail, had she followed discovery protocol when discovery opened, that is a voicemail that she likely would have gotten if she framed her requests appropriately for time period and the like. It
Instead
was
of
2
the
years before
discovery-
she got
Is
there.
that the spreadsheet that
That's
you're
the
referring
spreadsheet,
to?
Your Honor.
I need a magnifying glass.
I know,
plus,
Your Honor. I have to put it on an Elmo and project it to be able to read it, but
Let
yes.
me ask you, had she not forwarded it to her own email or given it to her attorney, but looked at it, remembered it, did everything else that she did, told her attorney about it, about
Or
this...
took notes on it
Or took
even.
notes on it, would we be in the same position? Would that be okay?
Well, under the case law, under some of the cases, the answer would be she would be permitted to do that. One of the questions about the reasonableness of her actions is whether she took the least intrusive method. Remember, however, none of these cases deal with privilege. This privilege
No, I
belongs
understand
to
that,
the
but she had
clients.
access to all, I question why all of this stuff was available anyway to people in the firm, like a voicemail transcription of conversations. But in any event, it was, and anybody could apparently go on and listen to this or look at it. And what they did with it was the question, not whether or not they had access to it, right? Because everybody had access to it.
The people with passwords had access, but
to
Your
it.
Honor, if
Not supposed to look at things? Could you be fired for looking at things you're not supposed to look at?
if you violated the policy, which says that you
But
can't
anybody
use it.
could look at it, right? Anybody.
Anybody with access could
Individuals
look
who
at it.
had passwords would have access to it, but the policy provides that they are not to make any use of the system except for the benefit of clients or the firm. So there is a policy very directly on point. It's on page 1498 of the
You could be
record.
fired for just looking at it if you didn't have a reason to look at it other than just curiosity? Well, you know, you don't have anything to do, you're just, you're there late at night.
Your Honor, it's a
waiting for your right.
hypothetical and very limited time available to me. I would suggest that it was an issue that was never confronted. This was not something that she just looked at. She emailed it to herself, and she acknowledges sending all 106 pages to her lawyer. I urge you to get that document. Those messages are privileged. I don't care what anyone thinks about the rights between the two parties here. You must factor in the rights of the innocent clients. Those messages were their messages, and there are two in particular in there that it is unbelievable that she took them. Now, the Board of Bar Overseers did not have the full transcription. That is also in the record. They had a small subset that she had selected, and so they never saw the pages that Judge Cosgrove saw and that Judge Laureate had available to him, whether he looked at it or not. And you can find that it is not the full transcript by looking at page, well, the full one's referenced at page 956, and then you can find later in there that there are references to the fact that only a small portion was being included before the board. So the board never, that's why I said to you especially that the board proceedings should not be a matter before this court. Mintz was not allowed to participate via written submissions. The standards for what is or is not ethical are completely different, and they didn't have the document.
Okay,
That's the key issue here.
I have a question that's not related to that.
Yes.
I understand your point. I'm not trying to blow it off. With respect to the determination, and the other challenged determinations made by Mintz, who are, in your view, who are the decision makers, and who is it that you say whatever they might have said is completely irrelevant to our consideration? I mean,
Well, I'm not saying it's completely irrelevant. The decision makers said things were perfectly fine that supported Judge Laureate, his decision that there was no contrary evidence at all. There were only two adverse employment decisions. The first was that she was asked to take a step back in seniority. The firm said to give her a longer runway. The three decision makers on that were Wendy Starr, HR director, Rosemary Allen, vice president of professional development, and then it had to be approved by David Barmack, who was then the head of the ELB section. Ms. Verdrager testified at her own deposition that she did not believe that Ms. Starr or Ms. Allen had discriminatory or retaliatory animus. They stated that they wanted to give her a longer runway because Mr. Popeo, who didn't even know her, wished her to have another chance at trying to make it at the firm. She was not doing well. Mr. Barmack did nothing, according to all three of them, but to say, okay, if that's your recommendation. So that decision was made without other input from employees who even Ms. Verdrager contended at deposition had no discriminatory
But
or
on the basis
retaliatory
of
animus.
information provided them by other lawyers in the firm,
Well, they were making,
right? I mean, it was on the basis of evaluations offered by other people in the firm.
well, it's the entire record, and the entire record included reviews from women partners, men
I
partners,
understand, I'm
and
just
others.
saying that. It's just that it wasn't.
it is the entire record.
Right, it's the
okay.
entire record, and she says she does not believe that they acted with animus. And Mr. Barmack was just rubber stamping. He didn't even know her. He was from
But
all
she
he had
says
met
some
her.
of the evaluators on whom they made that, on whom the decision makers based their decision, did act with animus, right?
But Judge Laureate, on review of the record, which you also have before you from summary judgment, said, I don't find that. I find no evidence of that.
But
It's just
but
what
we're
Ms.
in the same
Verdrager
position he is. I mean,
says. She
his-
can't
his
just
finding-
ipse-dixit it. There has to be evidence.
his findings are not binding on us.
What you are reviewing de novo, and they're not findings, they're rulings of law. I misspoke. What he is saying is, as a matter of law, I have reviewed this entire record, and she has put the entire record into the appendix, and reviewing the entire record, there is no evidence, that's the phrase, of retaliatory or discriminatory animus for either of the alleged adverse employment actions. There were only two, the step back and the termination. As to the termination, he found that Chairman Popeo, upon being alerted that among the materials she had removed were attorney-client privileged materials, terminated her or caused the Vice President of Human Resources to terminate her immediately. There was never any change in that testimony at all.
So she would have been fired even if she hadn't accessed documents relating to her case?
She wouldn't have been fired. She was on a layoff list. But she's never contended that the layoff was retaliation. It's not in her complaint. So it never happened. So I suppose she is saying to you now, well, I think, yes, she just did. I believe it was retaliatory, but it's not something that was ever presented to the court. It's not in her complaint. She can't add it at this point, I would respectfully suggest. Below, she agreed, and Judge Laureate... Okay, below she agreed that the only two adverse employment actions were the step back, that she was alleging, were the step back and the termination. I urge you to look at Judge Laureate's decision, as I know you will. He is a careful and considered judge. He reviewed the evidence with great care, and we request that you affirm what he has done. Thank you.